The position is quite clear. It is an important role of this court, which was designated in the African Union, to entertain certain disputes of this nature, breach of human rights. But as we pointed out in our oral presentation, as well as in our written submissions, it is important that this court has such role, but it can only have that role within the mandate that it has been provided for by the Charter, the Human Rights Charter, and the protocol establishing this court. So our argument is this case is a political case outside the realm of remedying violation of human rights, because the argument by Congo is that Rwanda committed an act of aggression. These are normally cases of international peace and security, and not human rights cases, the allegations themselves. So we do believe that yes, the court has an important role, but the applicant, the Democratic Republic of Congo, is trying to invite the court into a political realm on political matters that have nothing to do with the jurisdiction of this court. Politicization of courts by the Democratic Republic of Congo. You don't need to go further than to establish that they've brought a case here in the African Court of Human and People's Rights, and they've brought the same case in the East African Court of Justice. Actually, they made a grave mistakes by filing a case, the first submissions in the East African Court, and at times they forgot to even remove the logo of the African Court. But you don't need to go further also from the statements of my counterpart, the Minister of Justice, and the Deputy Minister, who have been on record stating that they are going to take Rwanda to all the available courts in order to deal with the cases. And let me tell you that these particular filings were brought just before the elections, the presidential elections in the Democratic Republic of Congo, after statements had been done that they'll fight the war both on the ground and in all possible forums, including the courts. Normally, there are two conditions that should be achieved before the case even go further. We like to say that even a journey of 1,000 steps, you have to take the first step. So the first step in judicial matters is establishing whether that court is competent to deal with the case. That means what is the mandate of the court? That's the jurisdiction of the court. Then the second step normally is the question of admissibility. Given what the court has been provided with, are there pre-steps that should have been taken before the case comes here? Tomorrow, you'll hear from the submissions of the Republic of Rwanda that first of all, there was no established dispute, or actually it was discussed today at the time of this case, because you have to have communicated to that country, show that we have a dispute on the application of this particular treaty. But all of a sudden in the morning, we just discovered that a case had been filed in different courts, including the African court. Then tomorrow you'll also hear that there are certain procedures that you have to fulfill, including the exhaustion of local remedies in order to bring the case. So these are preconditions towards bringing the case. So in legal terms, that's referred to as admissibility of the case. So these are the two issues that are at the point of contention today. And that is before we go to the substantive matter of the case, after the court has made a ruling on these issues. We do believe that our case is strong enough, and if you followed the case, we actually relied on the jurisprudence of this court, the jurisprudence of similar international courts, very strong legal arguments which have been established over the years. So we do believe that this court will deem it fit to actually dismiss this case, because it's wastage of time not only for the court but also for us as the respondent, who should be doing other important jobs back home, to really come here to argue on very flimsy arguments by the court. So we do have faith that the court will deem it fit on the basis of the arguments that we fronted, that they dismissed the case. It is possible also, it's a case, of course, that the court may find in favor of DRC that the case is, it has jurisdiction and the case is admissible. But then we will have to deal with that when we will cross the bridge when we reach at that particular bridge. Well, I didn't say that we can't sue them. The question is, can we sue them in the African Court of Human and People's Rights? And the answer is an emphatic no, because that's not within the mandate of the African Court of Human and People's Rights. But that doesn't mean that there are other courts which, if they have the mandate, we can actually bring a case before those courts and sue, because there's an egregious violation of human rights for many years by the DRC by supporting the FDLR, which actually has been designated as a terrorist group and has committed, has members who committed genocide against the Tutsi in Rwanda.